All right. Good evening, members of the Dangerous Building Board. As this board has not yet met, I will open the meeting. So I call the May 24th, 2022 meeting of the Dangerous Building Board to order. City Clerk, would you please call the roll?
Yes. Kirby Thomas. Debbie Allman.
Here.
David Bromley.
Here.
Ryan Lawson.
Here.
Joe Crockett.
Okay, I note that under new business, we have a few items of action. The first being the election of a chair. The chairman, once elected, will take over the running of this meeting. Does any member of the board have a nomination for the chair?
Debbie Allman.
I was going to nominate David Bromley, but so it sounds like it's going to be you.
Oh.
I can do it. I mean, if you want. I mean, however we do this. So
Good.
what do we do?
Yeah, do we have two? We have two nominations. David, do you accept your nomination as?
You can say no. I'll just do it.
No. Okay.
Yeah, okay.
So all in favor of Debbie Allman, say aye.
Aye.
Okay, Debbie, you're elected the chair of the Dangerous Building Board.
Thank you.
So now the next item on the agenda. would be-
Okay. Discussion, consideration, and possible action regarding designating Matthew Randall as the hearing officer for the hearing on 402 Northeast Poplar Court. Do we have a motion to designate Matthew Randall as the hearing officer for the dangerous building hearing on 402 Northeast Poplar Court?
Sure, I nominate Matthew Randall.
We have a motion.
Sir?
Would you like to second that motion?
Yes.
We have a motion and a second. All in favor? Aye.
Aye.
Motion passes. The next item on the agenda is the dangerous building hearing on 402 Northeast Poplar Court. Mr. Randall, the floor is yours.
Thank you. So I hereby call the public hearing to order pursuant to Chapter 503 of the City Code of Oak Grove, Missouri. The hearing concerns the building located at 402 Northeast Poplar Court in the city of Oak Grove, Missouri. My name is Matthew Randall, and I've been designated as the hearing officer of this proceedings by the Dangerous Building Board. The testimony to be given in this hearing shall be given under oath. All parties shall have the opportunity to be heard and present such evidence as shall be relevant to the determination of whether this structure is a dangerous building within the meaning of Chapter 503. I will ask each party to state their appearance for their record, spell their name, and have the city clerk swear in the witnesses. Who appears on behalf of the city?
John Mullane, John Mullane, appears on behalf of the city of Oak Grove as its attorney. With me is Justin Petre and Maureen Keedwell to testify as witnesses. Justin, will you please spell your name?
JUSTINPETRAY.
Maureen, will you please spell your name?
MAUREENKEEDWELL.
Who appears as an interested party in the property?
Good evening. Steve Maurer, Mauer, counsel for White Oaks. We have no interest in the building. We do own the land, but we have no interest in the building and no opposition to the building. And with me is our former property manager who is very familiar with this property and this problem, and her name is Christina Roberts, Roberts.
City Clerk, will you please swear in the witnesses?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give at this time shall be the truth and nothing but the truth under penalty of perjury?
I do.
Okay, for the sake of clarity, I will receive the testimony of the city first. When the city's testimony is completed, an interested party may cross-examine the city's witness. After any interested party has cross-examined the city's witnesses, any interested party may present their evidence. The city may then cross-examine any interested party's witness. Once all affected parties have had a chance to make their case and present evidence, the hearing will be adjourned. At such time, the Dangerous Building Board will issue written findings of fact and conclusions of law. Are there any questions? Mr. Mullane, you may proceed.
I call on Justin Petre as the city's witness. Justin, did the clerk swear you in?
Yes,
So you understand that your testimony is under oath?
yes.
What is your position with the city?
Building official.
As building official, what are your job duties?
I generally do plan reviews, permitting, inspections, new construction, sometimes called on inspections of renovations and dangerous buildings.
Do you have any special certifications or qualifications as building official?
I do. I have been certified through the International Code Council as a building official.
Did you personally oversee the dangerous building process for 402 Northeast Poplar Court?
I did.
And did you prepare a report on this property?
I did.
Will you please read your report for the record?
I investigated the building at 402 Northeast Popular Court on November 18th, 2021, took pictures. Maureen Kidwell, the ACO codes officer, took body cam video of the same. My report attached is Exhibit 1. I've noted on the inspection report the following findings. Once upon the structure and before entering, a strong smell of ammonia was present. After entering, the smell was so strong that PPE was needed. I observed feline feces on the floor and atop of furniture as well as appliances. Evidence of insect infestation by carcasses and dung. Trash, junk, and debris scattered throughout the structure. Only one smoke detector was in operation. No CO2 detector present, even with gas utilities to the structure. I was advised that the HVAC system was inoperable. Egress from one of the bedrooms was blocked. Subfloor throughout the structure was weakened due to urine saturation. The pictures and body cam footage that were taken on November 18, 2021 show some of these findings. The pictures that we have here in your packets, as you go through them, you can see evidence on the walls of what is dung. That is from flies, roaches. You can see the same evidence on the floor throughout. Of course, you can see the trash, the junk, the debris that's scattered throughout the house as well. This picture in particular, you can see what I had to do to go into the house with the PPE. I caught myself in the mirror. This is a picture of the bedroom that I was discussing that the egress is blocked. If there was ever an emergency and Mr. Steppe or another occupant were in the house, wouldn't be able to get out. This picture here is a floor that is just totally covered in cat feces. You can barely see the carpet. This one here, evidence there was other pets in the home other than cats. Birds, he had birds as well. The ceilings, of course, again, like I said, that's mostly dung and carcasses. Caught up in spider webs is what it is. You can see where one of the bathrooms, Mr. Steppe also told me that he had no hot water and was actually taking showers in the structure. This picture here is what I believe is horse bedding, the pellets. That's used to absorb, of course, horse pee. This picture is evidence again of fly dung roach dung on the jar. I tried to get pictures of every room just to show the severity of the living conditions for one, and what the structure itself was like. Okay, so this picture here, these are all in this bowl. These are all dead roaches that have crawled in there and died. The appliance is covered in dung. Not able to use the appliances. The cats have pretty much destroyed the house. This is actually, this is the back door where the subfloor itself was severely weakened. As I stepped on it, I had to step off of it because I was afraid I'd go through it. As noted on the inspection report written on November 18, 2021, these defects on the property structure mandate that the building be deemed a dangerous building in violation of the following subsections of Section 503.020, 1, 2, 3, 4, 10, 13, and 16. The pictures themselves will be marked as Exhibit 2. Body cam video that was also taken is marked Exhibit 3. And the inspection report marked as Exhibit 4. Certified copy of Chapter 503 is marked as Exhibit 12. On December 1st, 2021, the city obtained the owner's and encumbrance report from Security First Title, which lists White Oaks Crossing LLC as the owner of 402 Northeast Poplar Court. Personal property search through Jackson County records revealed that Gary A. Steppe is owner of personal property at 402 Northeast Poplar Court. Real estate property search through Jackson County records revealed White Oaks Crossing LLC is owner of real estate property at 402 Northeast Poplar Court. These are marked as Exhibit 5. On January 10th, 2022, a notice of declaration of violation in order to remediate was sent to the property owner, Gary A. Steppe, by personal service, certified mail, and posted on the structure. The inspection report, as well as a copy of the City Code Chapter 503, Dangerous Buildings, accompanied this mailing. Signed or unsigned certified mail return receipts, cards, and any returned regular mail are also attached. These are marked as Exhibit 6. On January 10th, 2022, a notice of declaration of violation in order to remediate was sent to the property owner, White Oaks Crossing LLC, by personal service, certified mail, and posted on the structure. The inspection report, as well as a copy of the City Code Chapter 503, Dangerous Buildings, accompanied this mailing. Signed or unsigned certified mail return receipt cards and any returned regular mail are attached. They are marked Exhibit 7. On January 10th, 2022, the building official posted the structure at 402 Northeast Poplar Court as a dangerous building, marked Exhibit 8. Pictures of that. On February 28th, 2022, speaking with Gary A. Steppe and further research revealed that the corporation company, CSC Lawyers Incorporating Service Company, Shell Point Mortgage Servicing, out of Greenville, South Carolina, Shell Point Incorporating Servicing out of Fort Washington, Pennsylvania, were all possible interested parties. On March 23rd, 2022, a notice of declaration of violation in order to remediate was sent to possible interested parties. the Corporation Company, CSC Lawyers Incorporating Service Company, Shell Point Mortgage Servicing Greenville, South Carolina, Shell Point Incorporating Servicing Fort Washington, Pennsylvania by certified mail. Again, the inspection report as well as a copy of the City Code 503 dangerous buildings accompanied this mailing. Signed and/or unsigned certified mail return receipt cards and any returned regular mail are attached. They are marked as Exhibit 9. After receiving no abatement plans within 30 calendar days from any party on April 22nd, 2022, I re-inspected the property visually from the outside, noted no change in the property's condition. On April 22nd, 2022, I posted the structure and sent to all interested parties. The Corporation Company, CSC Lawyers Incorporating Service Company, Shell Point Mortgage Servicing, Greenville, South Carolina, Shell Point Incorporating Servicing, Fort Washington, Pennsylvania, White Oaks Crossing LLC, by certified mail to give notice of the dangerous buildings hearing set for May 24, 2022 at 6 p.m. I also sent property owner Gary A. Steppe by certified mail on April 22nd, 2022, and by personal service, April 26, 2022, the notice of declaration of violation of order, inspection report, as well as a copy of the City Code, Chapter 503, dangerous buildings accompanied this mailing and posting. Signed and/or unsigned certified mail return receipt cards and any returned regular mail are attached. A copy of the mailing and posting is marked as Exhibit 10. Between April 22nd, 2022 and May 23rd, 2022, I periodically inspected the property to confirm that the notice was still posted. On May 9th, 2022, I had the notice published in the Focus on Oak Grove on May 12th, 2022, and May 19th, 2022, as a public notice for notice of the dangerous building hearing. That notice listed 402 Northeast Poplar Court, time, the date, and location of this hearing, and instructed inquiries to the building official. Copy of the notice are marked Exhibit 11. On May 12th, 2022, ACO and Code Officer Maureen Keedwell gained access to the structure with the property owner Gary A. Steppe to possibly rescue additional feral cats. She advised that there was no change in the property's condition. That body cam footage is marked Exhibit 3. On May 23rd, 2022, notice an agenda of dangerous building hearing was posted at City Hall, noting that this property would be reviewed. That notice listed 402 Northeast Poplar Court, time, date, and location of this hearing. That notice and agenda have been posted continuously on the bulletin board at City Hall since that date until today. On May 23rd, 2022, ACO Code Officer Maureen Keedwell gained access to the structure with the property owner Gary A. Steppe to possibly rescue additional feral cats again. She advised that there was no change in the property's condition. That body cam footage is marked as Exhibit 3. This is the end of my report.
Thank you, Justin. I would like to have the following exhibits admitted into the record, Your Honor. Number 1, the building official's report. Number 2, the photographs. Number 3, the flash drive with body cam footage from November 18th, 2021, May 12th, 2022, May 23rd, 2022. Number 4, the November 18, 2021 inspection report. Number 5, the title and property search records. Number 6, the January 10, 2022 notice of declaration of violation and the mail receipts to Gary Steppe. Number 7, the January 10, 2022 notice of declaration of violation, mail receipts to White Oaks Crossing LLC. Number 8, January 10, 2022 posted notice. Number 9, March 23, 2022 notice of declaration of violation and mail receipts to all the companies mentioned. Number 10, the April 22nd, 2022 notices and mail receipts. Number 11, the May 9, 2022 newspaper publication. And number 12, a certified copy of Chapter 503 of the City Code, the dangerous building provisions.
Those exhibits are hereby admitted into evidence. Thank you. Does any affected party wish to cross-examine Mr. Petre?
Madam Chairman, may I be heard for just a moment?
Sure.
I'm better when I stand up.
Okay.
I'm Steve Maurer again. I represent White Oaks. I really have no desire to prolong this process. We want this building declared dangerous. The problem is that the city has also issued a citation to us. And in fact, they issued a personal citation to Ms. Roberts as our property manager and brought her into municipal court trying to cite her personally when everybody knows all we own is the land, the dirt. We want this property gone too. I don't want to impede this process. I certainly don't want to point out any problems with the process that have occurred so far. So I'm trying to understand why we're here. If the city simply included us because we have an interest in the dirt, fine. But if there's some suggestion that we did something wrong on the dirt, then I need to proceed. And so before I spend a whole bunch of your time, kind of try to get a clarification of what is it that the city is trying to get vis-a-vis White Oaks. Thank you.
Who can answer that question for us?
I would just point out, based on the title records, White Oaks is the listed owner of the address 402 Northeast Poplar Court.
So how do we distinguish the land from the building?
Oh, I can answer that.
Well, I would just point out to Steve, there'll be an opportunity for you to present evidence. If you want to keep going, that's fine. Go ahead. If you answer, yeah, go ahead and answer the question.
We lease the dirt. When Mr. Petrie talked about the personal property and the title report, that is the property is the building. It is, in effect, it's like a mobile home parked on our lot. But Mr. Steppe owns the mobile home, and we don't own it. And there's a mortgage on it, on that property, on the building. There's a loan, just like a car loan, on that building. We want it gone too. We just own the dirt. And so we don't have any
Is
control
that the
over
mobile
that.
home listed in the documents?
Yes, ma'am.
Okay.
Yes. So I don't want to prolong this. I don't want to cross-examine Mr. Petrie on issues involving the land and what he did or didn't do involving the land if there's no issue vis-a-vis White Oaks. But the last thing we want to do is come out of here with another citation because they already issued a ticket to Ms. Roberts and brought her into municipal court only to have her cleared once we explained again. But, I mean, I even have the lease. The lease shows we only own the land. We have, we've canceled his lease. We've terminated him. He's got to go. It's just a matter of getting this dangerous building gone. So I'm just looking for the city. Tell me what it is that you want from why White Oaks has been brought into this when you know we only own the dirt. And we could probably all go home because Mr. Steppe isn't even bothered to be here yet. So I don't want to prolong this any further than I need to. So if I could get an answer to that, I might not have no questions.
I would say at this point is not the time for that question. I would say leading up to the hearing would have been the time. I mean, if you want to meet after this and talk, I think there's been discussions of coordination between the two entities, but at this point, as part of the dangerous building process, they are the listed owner of 402 Northeast Poplar Court of the land. So I think we're obligated to include them into this process. If the building commission, I mean, it's as part of your decision, doesn't want to include them on any findings you may or may not issue, that's the building commission's prerogative. But it sounds like, based on what I've heard before, the first step to anything included with White Oaks, based on their own letter to the city, was initiating a dangerous building proceeding.
And we're not saying anything about White Oaks. We're basically condemning the building.
Which is on the property that they own. Hence, they would be included on this. I mean,
Included, totally get that part, but what repercussions could there be for them based on this? Are there any?
that would depend on the board's findings. Were you to issue an order against White Oaks or against Mr. Steppe? Maybe or maybe not. Failure to comply with the order, if it's directed at White Oaks, could have up to a $500 fine per day.
Okay. Do you guys have questions about that?
So it's, I mean, it's up to the board's prerogative to issue its order on to whomever is interested in the property. It was the city's obligation to notify them of this hearing and include them. They are the listed owner of 402 Northeast Poplar Court.
So if we should say this building is a dangerous building, what effect does that have on these guys?
Well, hopefully, if
Well, then
you
hopefully it'll
issue,
get rid of him.
if you can get Mr. Steppe out of the house, have it declared dangerous so it can be demolished or removed, have it declared, everything inside declared abandoned so that there's no issue, because as soon as anybody, whether it's us or someone else, comes in to try to move that house or demolish it, any personal property inside, any furniture, whatever, is gonna be lost. And fine, we're more than happy to have that happen. We want that to happen, but we obviously can't go in and clear off the lot if there's somebody inside the house or if there's animals
Is he
inside the
living
house
in
that
that
we don't
home?
own.
Do we know, is he living in the home?
He is in there and out, he's in and out and in and out, and Ms. Roberts saw him just this weekend there. So,
If I may, the public hearing is open for any interested party to submit evidence to this board, right? And then as a board, you may adjourn and take all of that evidence under advisement before you make a decision.
Okay,
So if Mr. Maurer wants to provide testimony as to the role that they, as an LLC, White Oaks has, as the property owner in relation to a house, a trailer that is on their property, I think he has made that point. And so if I may, would like to continue on hearing any other party's evidence, unless Mr. Maurer has more to add, and then you all could certainly take all of that under advisement as you make a determination.
okay.
okay, then I guess I have some cross-examination for Mr. Petrie. I really did try to shortcut this. Mr. Petrie, in your testing, do you have any sample borings of the land?
I do not.
Did you do any environmental testing on the land?
I did not.
Did you inspect it for any dangerous holes, abandoned wells, anything else that might be of danger to someone trespassing on the land?
I did do an inspection outside the house, but I did not find evidence of that, no.
And you said that on 4/21, I believe, you went by the property to re-inspect from the outside, correct?
That is correct. I did not gain access.
Right? Did you actually walk around the house or just drive by?
Oh, I actually drove by.
All right. So did you actually go on the land again on 4/22?
No.
And sir, did you speak with anybody at White Oaks on or after 4/22?
No.
Did you observe whether the ground had been treated for insects and other infestations to try and stop the insects and other infestations coming out of the building onto the land?
I did not see evidence of that, no.
Did you ask anybody?
No.
Would you been able, if it had been done, would you have been able to observe that just by driving by?
Well, with the amount of cockroaches that were in the house, I'm sure I could have.
As you drove by?
Correct.
And you didn't bother to stop and look or ask anybody at White Oaks if in fact they treated the ground to try and stop the infestation spreading from inside the house onto their land?
I have not had that conversation, no.
Thank you. Nothing further.
Have you done treatments to the outside?
Yes, sir.
You're speaking.
We are doing everything we can to try and stop it to spreading to the neighbors. But as long as the house is still there, it's like trying to hold back the tide. And we can only do so much.
Can I say something? As far as the outside, currently, it has not been mowed and is in violation by height, allowing for more animals and vermin and insects to be in that land.
Whose responsibility is it to mow it and keep it?
My understanding is it's White Oaks because it is leased property.
Are we going to swear in this witness, or do you want me to just ask
She
my
was already
questions now?
sweared in.
Oh, okay,
Yeah.
so I just didn't want to
Sworn
get
in.
out of order.
No, no.
Have we moved on,
I would
or?
go back and, Maureen, we'll have a few questions for you. I think we should get back in order. And then
Okay.
White Oaks will have their opportunity to go. Well, I guess.
Yeah, I
that's
mean,
the
does,
next
the-
question.
does the board have any questions for Mr. Petrie?
No.
Not for Mr. Petrie, no.
Well, I do call on Maureen Keedwell. Maureen, did the city clerk swear you in?
Yes,
You understand your testimony is under oath?
yes.
What is your position with the city?
Animal control and code enforcement officer,
And how long have you been doing this?
approximately 5.5 years.
And as codes officer, what are your job duties?
I enforce nuisance ordinances and property maintenance codes.
And have you personally inspected the property?
Yes.
And what issues did you see?
Infestation of roaches, and just the odor. There was too many cats, which leads to the saturation of the floor. And there's currently overgrown grass. Trying to think, there's just a lot of issues. But the biggest one is probably the roach infestation and the odor.
And you inspected the property yesterday on May 23rd as well, correct?
Correct.
And also again this morning, May 24th?
It was this afternoon.
Oh, this
yes.
afternoon.
Yes,
And the issues still persist.
yes,
So is the structure dangerous?
definitely.
And I guess then the last question is, you issued citations to the property?
I did.
Thank you. I have no other questions. I guess the only other one would be I'd issue the copy of the citations as exhibit number 13, I think is what I'm on.
Exhibit is hereby admitted into evidence. Does any party wish to cross-examine Ms. Keedwell?
I guess I do. Ms. Keating, is it?
Keedwell,
Keywell, I'm sorry.
that's okay.
Ms. Keywell, in your position for the City of Oak Grove, did you also issue a personal citation to Christina Roberts?
Yes,
And in fact, you hauled her in here to municipal court and made her appear in front of your judge, isn't that true?
yes,
And you were here and personally testified in that hearing, isn't that true?
yes.
And at that time, were you asked the question, did you expect White Oaks or Ms. Roberts to do about this house that they don't own? Didn't that occur?
I believe so.
And in fact, you said there's nothing because they don't own the house. Isn't that true?
The nothing was in response to, did she have legal access into the house? And that was no.
And so it is true that Ms. Roberts and White Oaks can't even go into the house, and you know that because we don't own the home. Isn't that true?
That is correct on that part.
And so the charges against Ms. Roberts were dismissed. Isn't that correct?
In court they were?
And did we not present to you at that time, to the municipal court, a copy of the lease to show that we only own the ground, not the building?
Correct.
So the City of Oak Grove knows that we only own the ground, not the building. Isn't that true?
Correct. But as a,
Ma'am, my question is, isn't that true?
yes,
So here we are again, you've cited White Oaks again, talking about this building when Oak Grove knows we don't own the building and we can't even go inside the building. Isn't that true?
I know that you cannot go inside the building, yes.
And you know we don't own the building. Isn't that true?
Yes.
Right. Oh, one other thing. Have you ever examined the mowing opportunities and services that are offered by White Oaks? You ever seen that program that White Oaks offers to its residents?
No.
Do you know if Mr. Tsepi ever signed up to actually have the property mowed by White Oaks?
I believe at one time I was told that they mow it because it was leased, but I couldn't tell you what date I found that out because I'd been out there for a while.
Do you know if Mr. Steppe mowed the grass himself and opted out of the city of White Oaks mowing program?
That I do not know.
Thank you. And did you do anything to contact White Oaks to find out if they had treated the ground to try and stop the infestation from spreading out of the building onto other property?
We had discussed it, but I never asked them if they had specifically done it.
Thank you. Nothing further.
Do any of the board members have any questions for Ms. Keedwell?
What is it that you think is the responsibility of White Oak?
As the codes officer,
Uh-huh.
if I go to any house, generally, if it's a rented house, we'll contact the tenant and we contact the owner. So say I go to a house and someone has a trailer, like a car hauling trailer or an RV parked on the grass, it's the tenant's problem because it's their trailer, but it also because it's on the property of the homeowner. We could cite them. Generally, I try to go for the tenant, but we do have to let the owner know, and that is in our ordinances. So with that house being personal property on a piece of land, that's why we cited them.
How is this trailer or mobile home attached to the land right now? Is there a foundation or is it just sitting on blocks or? I mean, it's attached somehow to the land that he's leasing. I guess that'd be to you.
I'm sorry, I don't want to go out of order again and cause trouble.
I know.
It is up on blocks, and there's a foundation around it, so it would look, from the exterior, more like a regular house, but it is not affixed to the land. Under Missouri law, the home is treated as personal property, just like your car or your boat or your mobile home. It has a VIN number just like your car, and it is treated just like personal property, owned by Mr. Steppe, not by us.
What do you do with other tenants that have something on your property that you need removed?
Typically, once the home is there, the home will be sold on, and if someone wants to buy the land from us, we can sell the land to them, and so they can unite the lot with the home, and it becomes like any other piece of real property. Sometimes for tax reasons, people like to keep the home and the lot separate. And in this instance, Mr. Steppe only wanted to own the home and not the land, and so we lease the land to him. It would be very unusual to have one, though, moved. It can be done, but it would be very unusual. In this instance, my guess is it's going to have to be demolished.
Has he been keeping up on his lease payment?
We've terminated the lease. We're not taking his lease payments. We want him gone. We want it gone. So no, we've done everything we can to stop it.
What resolution would you say that Oak Grove, from this hearing, wants, determining that it's a dangerous building? And what effect does that have from here on out? We determine it is dangerous and agree, and then what is the next step? Does anybody? Yeah, do you know?
I was asking me, I personally don't know. That would probably be a Justin question.
Justin, if we determine it is a dangerous building,
Depending on your order, whether to renovate it or, demolish it, the owner would have a certain amount of days, specifically 30, to appeal your decision to circuit court. Once that time is up and that appeal is not made, then that's when the city can go in and do the order. And
when you say do the order, does that mean you can demolish?
if that's your order.
Demolish or whatever we say you do next. And what, if anything, is White Oak's responsibility in that? Is there any?
As a property owner, I believe so.
What would it be?
Well, depending on your order again, if the order was to demolish the structure, it would be up to the property owner to demolish that structure.
Okay.
And in this case, White Oaks has a interest in that property as a landowner. Mr. Steppe as the owner of the mobile home, manufactured home.
Okay, thanks.
Ultimately, if the city goes in and does the abatement, then a lien will be put on the property.
For the amount of the abatement? Okay. You guys have any other questions?
The city has no other evidence, so if that's,
We keep saying White Oaks as the property owner. They are the land owner, but not. I'm getting a little confused with the terminology that's being thrown around. So there's the owner of the land, there's the owner of the building, both which are technically property, quote unquote. But when we are saying White Oaks is the owner of the property, what specifically are we mentioning when we say property?
The condition of the entire property. I mean, the house, ultimately, White Oaks was getting complaints from their residents about the condition of this house, this trailer. And, well, their lack of enforcement on that property owner that leases that ground from them, who also pays HOA dues, that lack of enforcement, the citizens came to the city to complain, which ultimately led to myself to go out and Maureen to go out to gain access to the property and do the inspection and see the condition that this house is in and that this gentleman is living in. So, you know, this has been quite the situation with the fact that White Oaks owns the land, but Mr. Steppe owns the trailer. And in my opinion, both are responsible for how this house, this structure, has become. So I can't give you my opinion on what we need to do with it, but ultimately, that's your decision.
Okay, so there's a lease agreement between White Oaks and the gentleman who owns the home.
My understanding.
Is that correct?
And if I understand him correctly, they've terminated that.
Okay. Prior to termination, though, has that lease been admitted into evidence?
I don't have it.
Okay. What about complaints that have been filed with White Oaks before it was brought to the city?
They would, I'm assuming they would have a record of that.
Do you have a record of any complaints filed with White Oak?
If you'd like me to address that, the complaint came from White Oaks to the city. I have an email I can give you. Call it White Oaks 1. I didn't bring quite enough copies, but. This is the ultimate of irony. We were the ones that complained to the city. Ms. Roberts was the one who said, I've tried everything I can. I've called your codes enforcement. I've tried to get you people to come out and help. She reached out to Mr. Randall, who I really don't want to call as a witness, but this is the ultimate of no good deed goes unpunished. We were the ones that tried to get the city to come in to help enforce the codes because Mr. Steppe was not responding to us. Here is the lease. going back to 2002. It's rather long, so I only brought 2 copies.
That's fine.
And we then, when we couldn't do anything else and we were getting nothing, we terminated the lease on January 19th, 2022. You can see we terminated the lease, call it White Oaks 3, White Oaks 2 and 3, leases 2, terminations 3. And in response to that, all those efforts, Ms. Roberts gets a ticket and hauled into court where they tried to personally fine her for the condition of this house, that they admitted she can't even go inside. And now you're trying to punish White Oaks when they haven't done anything testing on the land. And just because this home is there, and we came to the city to do is please declare it dangerous so it can be torn down. And hence my question in the beginning, what is it that you want from White Oaks? Because it's not our control to do anything other than to terminate the lease and tell him he has to move his house or vacate it, which he won't do. And so if the city will declare it dangerous, it can be torn down. We're more than happy to have that happen. But there really isn't anything else we can do, but it seems like every time we come to the city for assistance, we end up getting a ticket. We end up getting a citation when they know it's not our house. Since you asked for that information, sir, I'm sorry to jump in, but I went ahead and gave it to you and provided it. So White Oaks 1, 2, and 3 would offer, and just for clarity, I'll give you White Oaks 4, which is a copy of the citation that the city issued to Ms. Roberts personally, trying to personally punish her for this home that she was nothing but the property manager. And Ms. Roberts is here. If you have any questions for her, you're welcome to ask, because she knows and has lived through this a lot longer than I have. And I'd move for admissions of White Oaks 1, 2, 3, and 4.
I have no objection.
The exhibits are hereby admitted as evidence.
I would just say, since, Steve, if you've offered testimony, I would have a couple questions just for you. Or
Sure,
So-
either one of us.
I guess my first question is, it sounds like the relationship of White Oaks is the landlord, quasi-landlord for Mr. Steppe?
For the land, yes,
For the
we own
land.
the land. Well, we're the former landlord. We've terminated his lease.
But the structure is still on the property.
Correct. His home is still there.
And during the pendency of your lease, the structure obtained all these conditions we've previously described?
No. It has gotten considerably worse in those inspections, and, it continues to deteriorate even after we had these conditions, which is why we came to the city in the first place.
When was the lease terminated?
January of 2022, excuse me.
And then I guess I'd ask, what is it White Oaks would want of the city vis-à-vis this dangerous building process? You talked about that. Just to clarify one more time for the board.
We don't want to get another citation from the city of Oak Grove. We came to the city asking to cooperate and help. And we wanted and thought we would get the city to inspect. The city would determine and issue a citation and make Mr. Steppe either clean it up, or he would be required to vacate, remove his animals, remove his property, and then the building could be either rehabbed or most likely demolished. And we want it gone too, and more than happy to assist in that. We just can't, we don't have the legal authority to do that. You all do. The problem is, every time we come to the city for assistance, we keep getting a ticket and a citation, as if we've done something wrong.
So to clarify, it's White Oaks' position as landlord, it has no legal authority to remove the personal property of Mr. Steppe from the land it owns.
Not at this time, no, sir. There is no judicial order that would allow us to do that. There's no enforcement that has allowed us to do that. And when trying to get service on Mr. Steppe to do that is very difficult, which is why the city, with its posted notice, can expedite this and get it done a heck of a lot faster than we could through a lawsuit and a court proceeding.
Thank you, Steve. That's all I had.
I do have one other thing, if I could. I had no idea that you were going to be the hearing officer, but just so to clarify, and maybe Mr. Randall can just verify for me instead of having to testify, but we even offered to pay for the demolition, even though it's not ours. We even offered to pay for it if the city would just carry through. I believe that's correct. Mr. Randall?
Yes, you did send a letter that provided that White Oaks would pay for the demolition, provided several things that you wanted to occur in order for that to happen.
And just
I
so,
believe also you wanted a competent court to declare, beyond just this board, to declare no one had any further interest. You also want us to evict Mr. Steppe and any animals that were on property, and there might have been a couple other conditions as well per your letter.
just so we're clear, if you declare this a dangerous building, you can require it to be vacated. You can enforce that order. You can then also declare, give him a certain period of time to remove anything that's inside. And if it's not inside after that, it's declared abandoned. You've noticed the property lien holders to the extent that there are any, and they've not appeared. So again, you can declare their interest vacated. And if he doesn't appeal in the 30 days as been laid out by Mr. Petrie, you'll have an order. And so in a month and a few days, depending upon the timing of your order, this could be almost done, far quicker than we could do anything through a lawsuit or anything else, when we don't even have the authority to enforce that. And so this seemed like the greatest cooperation we could do. Yet again, we keep getting citations as if we did something wrong, even though we agreed to pay for it.
What citations have you received besides the personal?
Oh, we received this notice, and the city is declaring that it's our dangerous building and trying to cite us for that and threatening to put a lien on the property. Understand that you can put a lien on the mobile home.
Right.
That's fine. But putting a lien on the dirt would be a real problem for us because we own the land, and there's nothing wrong with the dirt. You move the home away, the land is fine. But the threat from Mr. Petrie and from the city has been, well, we're going to lien your land, even though we're saying we'll agree to pay to move the house off so the land is fine. So that's the problem.
Got it.
Thank you. Did you have anything you wanted to say? If there's any questions for Ms. Roberts, she has lived through this entire scenario. All of her contacts, I'm sorry?
Since 2013.
Yeah.
Well, I just got a question on the lease. I have read through the lease. You don't have any other remedy to, once a lease is up or broken, the way that you have for this property, you don't have any other remedy to get them off of the land?
Well, eventually, we would have to go through a process for breach of the lease, and then we'd have to sue, and we'd have to get a court order requiring that he vacate the building, move the building, and remove any personal property, and he would have the opportunity to appeal. I mean, understand, Mr. Steppe, it's not like he's cooperated with us or you. You already cited him for a nuisance violation. He appeared in court and he paid your fine. So it's not like he's just going to go quietly into the night and just leave. We've talked to him many times. Christina can tell you about how many times he said, oh, I'm moving out, I'm leaving, I'm vacating, and then he never goes. So something official needs to happen, and you are in a far better position to make that happen quickly than we are.
Thank you. Any other questions?
Yeah, I have a couple. Okay, so not having much, just kind of skimming through this lease agreement, I see that this is for 2002, December 1st, 2002 to November 30th, 2003. Is this one of many, I'm assuming he has renewed that lease up until you said the lease was terminated this past January, or?
The lease automatically renewed. Christina can tell you about that. Go ahead.
It automatically renews into a month-to-month until further notice. There's a section on that lease that states that.
Okay.
Oh, it does on the Also on the notice to quit, talks about it. So you gave him till the 28th of February. He's still there. Your only remedy now is to continue the process.
Right.
Did you say you had another question?
Not sure if it's here in this packet of documents right in front of me right now or not. Are there currently any, do you have any current citations? Or have they all been settled with the municipal court already, at least up until this point?
You mean for this Steppe property?
Yes.
Yeah. We only ever had the one, and it was personal to Ms. Roberts. It wasn't even like they cited White Oaks, they cited Ms. Roberts personally. There are no others.
Okay. I don't have any other questions at this point.
David?
No, I'm good.
Do we
Just-
have, oh,
I'm sorry, just one other thing to remember. This problem has been, going on for a while, but only until very recently were landlords even allowed to bring eviction actions due to COVID.
Right.
And the backlog of those actions is tremendous. So us even initiating a lawsuit is going against Mr. Steppe to evict is going to be months and months and months, as compared to if the city just enters its order, we could move a whole lot quicker.
understood.
Thank you.
Anything else we need to cover in the proceeding?
No, not unless you have any more questions for any of the witnesses.
No.
If not, you could adjourn and take the evidence under advisement.
Do we have,
Just gonna say, I moved that we
do we have a motion to take the matter under advisement and direct staff to coordinate a meeting of this board in the next couple of weeks? Second? Thank you. We have a motion and a second to take the matter regarding 402 Northeast Poplar Court under advisement. Any discussion? All in favor? Aye. We're taking the matter under advisement. Do we have a motion to adjourn?
make a motion that we adjourn.
Yes. Okay, we're adjourned.